Good morning and welcome to another edition of Brown & Crouppen Facebook Live. We do this every week discussing different legal topics. If you're not already a subscriber, please subscribe to this so that you can get these videos every week. This is a topic that was actually requested by one of our viewers, and so if you have any topics that you'd like to see us covered, please put it in the comments. This topic today is all about the ways that employers and work comp insurance companies basically trick injured people out of getting all of their available benefits. And we have with us today, of course, Andy Crouppen, who's always with us. We have two of the most veteran work comp attorneys in all of St. Louis, Mark Elhofer and Brent Cantor. And just to get the ball rolling, Brent, start with a big one. What's a big way that they basically screw victims?
All right, so the first step is they deny that an injury ever happened. So let's say you get cut on a machine at work, and you go to your boss and they refuse to take a report of injury. They just pretend like it didn't happen.
They'd rather have it go away.
Well, what do you do? I mean, what should a person do? Let's get real basic. Person gets hurt on the job. What's the first thing they should even do?
They need to report it to a supervisor. If it's verbally, that's okay, but it'd be better if you could maybe even send an email. That'll document the time because you have 30 days from the date of the accident to accident.
So that's a big deal. That's a big deal, and that's great advice. So what you're saying is, if they don't want to take that report because they're trying to maybe delay you, or maybe they even say, "Oh, we'll talk about it in a couple of weeks," so that the 30 days go by, you're saying a person can actually protect themselves by sending an email, something will be a digital record where they're making their own report of injury and sending it to a supervisor. Is that right?
Right. Or some note, then they keep a copy of it. Or if they have a witness.
Now, what about a situation where that makes sense if there's a particular injury, like, something cut my hand. What about a situation where they develop a repetitive motion injury, a carpal tunnel? What's considered the 30 days? How do you report that type of injury?
The most common example is of course, clerical people who develop carpal tunnel. The time in which the kind of clock begins is at the time that they know that they have a work-related condition. So if I go to the doctor, my wrist hurts, I don't really know what is causing my wrist or shoulder or knee because it's been happening over time. I don't know what happened. And when I go to the doctor and the doctor then explains, well, what do you do or ask, what do you do at work? And I tell them, oh, I type all day. And they say, well, you might have a work-related condition. It's at that point, the time that you know that it's from work, that you have an obligation to report it.
Okay, so then what's next? So the first one you mentioned is they don't want to report the injury and have a record of it. What would be another example of a trick?
And this is a kind of a corollary to the not taking the report of injury, which you should always insist that they take. And I'll also add that you can go up another layer of supervisor. If you're a supervisor who doesn't want to get in trouble because they failed to violate some safety rule, go up to the next guy and insist that they take that report of injury. But something similar to that is they may say, you know what, don't worry about it. We're going to pay the bills. They'll send you the emergency room. Somebody will drive you to the hospital, and they'll say, don't worry about it. We're not going to report this. We're just going to take care of all the bills.
Especially in smaller businesses, sometimes that'll happen. And even sometimes it's not born out of a desire to hurt someone. It may start as genuine. I'm going to take care of you. I'm going to figure it out. I'm going to get you there. And then they kind of get in over their head. They offer to pay medical bills. The medical bills get a lot. Now you haven't reported it to comp because they didn't want it to go to their comp. And now you're in a real bind. So,
and then the employer doesn't want to because he should have told the insurance company.
That's exactly right.
And he's sitting on all these bills. So you just got to go with an attorney and go file it at that point.
No, it's really true. I think you don't want to fall into that trap of being convinced that even if your employer is, you've known him for 20 years and he's genuine, he's going to take care of you, sometimes he can get in over his head and then not have a choice but not to pay you. And so you've got to always insist upon making that report.
Right, that makes good sense. What else you have?
So the next one, and this is probably the biggest one, is you typically go to what we commonly call their doctors. It's the work comp doctor. It's the comp doctors that Mark and I, who are in the practice, we see the same names day in, day out, every single day. We know these doctors and what they're generally going to say, and they're not going to come out favorable for you most of the time.
We'll talk about that, and Mark, if you want to pipe in on it, talk about what happens. So, okay, I'm hurt on the job in Missouri. I report it, and they say, okay, you're going to go to our doctor. What does that mean that it's their doctor? What's the difference between what their doctor's going to do for me and what
generally it's going
to
be more of a conservative approach. They want to keep it minimal. They don't want to do any diagnostic testing. and you may be sitting there with a low back injury and you're noticing numbness or pain going down your leg or your arm. With a neck injury, you might have it in your arm. And you need to push that doctor to get an MRI. If they refuse to do it, you need to talk to your attorney, if you have an attorney, or you need to push that doctor and get an MRI done, because you could have a serious injury with a disc pressing on a nerve that needs to be repaired quickly. The longer it takes, the worse it
Now,
goes.
not to get too basic here, but just so the viewers understand, why doesn't that doctor want to do that MRI? Why don't
the
they
motivation on the doctor is essentially he gets a lot of business for workers' compensation. It's pretty regular business for him. He'll give the employer a little bit of a discount when he gets paid, but he wants to keep that business. And the way to keep that business, and I don't mean to say all doctors do this, but it sure seems like that could be the case. They will go ahead and give them a good discount, and they'll treat them conservatively. It should be focused more on what the employee needs for treatment, period, no matter what the cost is, and that includes an expensive MRI. It does.
I think you bring up a good point. We're not trying to vilify doctors.
Right.
I think when you say it like this, it sounds kind of more obvious than it actually is when it really plays out. It's subtler than that. It's situations where maybe there's a judgment call that, some reasonable doctors would go this way, some reasonable doctors would go this way on this call. But these doctors always just sort of take the conservative approach that seems to be on the side of the employer. Not that they're doing it's not like somebody's walking in with a broken arm hanging off like that and saying, looks fine to me.
Right. They're not going to commit malpractice just to save an employer money. But like you say,
they'll err on the side.
They'll err on the side of let's do nothing and see if it fixes itself.
Right.
Or let's do very, very cheap treatment. Let's give them ibuprofen, or let's give them some moderate physical therapy.
Right.
When in reality, it would probably be smarter, and some other doctors would go ahead and say, let's find out exactly what we're dealing with here. Let's do the MRI first. And we can look at the MRI, and all of a sudden, whoa, well, there's the problem. That's a disc bulge. That's a herniation.
Right.
That may require, surgery or injections, but see, surgery and injections are much more expensive than just physical therapy. So that sounds like what's going on here.
Well, and they also know that if they can delay it a little while, a lot of people need to get back to work. And so what'll happen is like you say, they don't throw everything at it at first trying to figure out what's wrong. They start with a conservative course of treatment. People may say, hey, I got to go back to work. I'm in pain. End the comp case. And then later on find out that there's something more significant going on, but maybe by that time the case is closed or it's related to something else.
And let me offer two things where we've been using the word as conservative approach, but two things they typically blame, and they being the work comp doctors, is your age. If you have a degenerative condition, if you're 35 years old or 45 years old, everybody's MRI, or most people's MRI, are going to show some pathology. The other thing that they may try to blame is your prior accidents. And the thing to stress there, and now I want to kind of get into the solution, and the thing to stress there is that, one, if you haven't had previous problems or prior problems, is to let the doctor know, I've never had any problems in the past. If you have had a prior injury and the doctor already knows about it, let them know that, that was 10 years ago, I haven't been to the doctor in the last 10 years and I haven't seen anybody. The other thing to do, and I'm going to give a shout out to Carrie O'Sullivan in our practice, is when you have injuries and you feel like the doctor's ignoring you, because frequently you're going to feel like the doctor's ignoring you. What we recommend that you do is write out a list. And you write out, it hurts when I do this, it hurts when I get out of the car, it hurts in the morning, it hurts when I'm lifting my arm, I can't do the dishes, a gallon of milk. Whatever your list of injuries might be, write them out on a piece of paper, have a copy for you, and physically hand the copy to the doctor. Doctor, I'd appreciate it if you make this a part of my file. That way there's no denying later on, a year later, when we're fighting about this in court or however long it is, that these people actually told the doctor that these complaints exist, because a lot of times the doctors will be ignoring them or taking it very like, no, you're really okay. Of course, everybody hurts to get out of bed in the morning. Right. So by making this comprehensive list...
Oh, that's a great idea.
Yeah.
It really helps.
It's also no surprise when they pull up all of a sudden a shoulder injury 3 weeks later. It's, well, that can't be related. But if you give them the list, they know that was part of it. And they can't back out of that.
No, that makes good sense. Now, again, just to get a little elementary, we know when someone's hurt on the job, we know that the medical bill should be paid by the employer. If they miss a certain amount of work, they may be entitled to some lost wage benefit. But talk about the big benefit, the third benefit, and the one that employers sometimes hide the ball on and don't tell their own employees about. Talk about
typically what happens in a case where there's like a fracture or something, there will be a potential a rating from the treating doctor, and they'll make an offer for the rating doctor's rate. And he's going to be very conservative in his estimate.
And this is for a lump sum settlement. So in other words, they get the bills paid, they get some percentage of the lost wages, and then they'll be entitled to some lump sum settlement based on the degree of their injury.
Yeah,
and if I might interrupt, that's part of what you're getting at. Is a lot of times the employers don't want you to know about that step. They you know, you feel like you're getting paid while you're out. They've got the doctor who's put you in the cast, and you're going to go back to work, and they've taken reasonably good care of you. The doctor's taking care of you. You think it's all done, but this is where it comes in. You may be entitled to a lump sum settlement.
Well,
at the conclusion of the case.
Kind of is related. Stepping back for a second, the third part, I think it's important to look at what comp is. Work comp is essentially designed to protect your current and future ability to make a living. There's no pain and suffering. There's no anything like that like you find when you have a car accident. So with this third component, it's really based on when we talk about an injury, we're looking at an injury in terms of the future or the disability and your future ability and how it hampers your future ability to make a living. So you hurt your arm, you break your arm, it may feel pretty good. You don't heal to 100%, you may heal to 90% or 95%. And that's what you were about to talk about, is when you talk about that percentage is a percentage of disability. So how close to whole did you get when you were healed?
And the doctors who treat it are generally going to be very conservative. Again, we use that word a lot, but of course the doctor did a great job.
99%.
He did a great job.
He's the same guy he was before.
That's what he's going to say.
Good as new.
And so they'll give you, but most of the time it's such a conservative rating that you're entitled a lot more, and it might need to have your own independent medical evaluation done by one of our doctors that we send people to get a rating. And we may not get our rating, but they're not going to get their rating, and we were able to resolve this or take it to trial. You have to be able to prove that there is a permanent partial disability in order to take it to trial.
Let's talk about intimidation. I know people call up and they're nervous about pursuing a work comp claim because they think their job may be in jeopardy. That's one type of intimidation you hear about. I want you to talk about that, and then we'll talk about drug testing. So talk about that. Can a person get fired for filing a work comp claim?
No, but people
can they or do they
People do think that just because they've been injured on the job, their job is protected, they can do anything. But that's not what we're talking about here. What we're talking about is the ability for an employer to mess with someone a little bit. And you notice I just had a person that I found out about that just had a work comp injury, and he was written up for a tardiness that happened last year. Obviously something's going on, and it's a pretext that they're trying to work up. So we have to kind of make sure that we let the attorney know we're going to be on this, and if there's a wrongful termination that takes place, you can't terminate someone if it's a motivating factor.
So essentially, to answer your question directly, an employer may not terminate an employee for exercising their rights under the Missouri Workers' Compensation Act. That's the bright line rule. If somebody gets fired for saying, I need to go see a doctor because I injured my shoulder, and they terminate them, that's illegal and can have a separate cause of action, as Mark starts to get into.
Right, but I think what you're also saying is you can tell that sometimes employers will try to generate other grounds.
Right, and you don't want to give them any excuses or anything. I mean, you want to be a good employee, and you're expected to stay on afterwards. And for the most part, Missouri employers will allow that. But there are these employers, and you'll know who they are, that are going to start messing with you. And sometimes it's just best at some point to say, look, I understand this, and this is not a good place to work. But you cannot do that. It's illegal, and it's going to open up a whole other cause of action.
Okay. And it's not to say they can't fire you for something that led to your injury. For example, if you came in drunk to work and then you trip over in this office a file and I get hurt, I may have a comp claim, but I might also get fired for coming into the office drunk.
Okay.
So you're not insulated from being terminated.
Since you bring up alcohol, talk about drug tests and how they're sometimes used legitimately and how sometimes they're used just to intimidate.
So the first test is whether or not the drugs or alcohol is in conjunction with. Did me being drunk cause the injury? And that could be a complete bar to receiving your workers' compensation benefits. more often than not, the way that this comes into the workers' compensation system is somewhere in between the time they are injured and they're getting treatment. They get drug tested, and sometimes the person tests positive for marijuana use, and you get into a whole host of issues with regards to how does a positive drug test interplay with their benefits under workers' compensation. And again, it gets very complicated, and the law kind of hasn't really caught up to kind of.
For instance, marijuana will stay in your system for 30 days. Other drugs are metabolized much faster.
Yeah, like with alcohol, if somebody's drunk, you can test them. How does that work? Let's say you have somebody who says, I was not smoking marijuana at work, or that day, or that week for that matter. It was 3 weeks ago.
But you still test positive. Well, those are very tough cases because there are issues you got to deal with both sides. I think that, I guess what I would say is, first off, don't smoke in conjunction with is a word that they use, and conjunction means...
Oh, come on, Mark, you're no fun.
Yeah, well, conjunction is a very difficult term. It's a legal term that they're trying to evaluate at the comp system. And it could be that it didn't necessarily cause it. It just was in your bloodstream at the time somebody rear-ended you in a car.
And then the next phase is whether or not that violates an office policy. So if they have a specific policy, and sometimes they do it for like security clearance or things where I may not, under any circumstances, test positive for marijuana. It's an automatic termination. And they happen to catch, because of the accident and the blood drug test, at that point they could catch that I had marijuana in my system. That would be a violation of the policy, and therefore could be a penalty. It will be a reduction of the benefit.
Really? So I understand that they can fire them if it's a violation of office policy. If it's in a role that's really a pretty, like a security role, or if you're operating heavy machinery and they say no, zero tolerance. But they don't have to prove or somehow give some pretty compelling evidence that marijuana wasn't from this morning when you were driving that forklift. You're saying that was 3 weeks ago. It was New Year's Eve. Give me a break.
And in that scenario, it's a penalty. It may reduce it, I think, 15 or 25% of the total benefits.
And it's all benefits too. It's also on the hospital bills that are being paid. They could take a penalty on that too.
Maybe.
Who determines? Is it the judges? Ultimately, the judge who decides, or is that an automatic statutory reduction?
It is. You were able to. It's a presumption created that it was used in conjunction with when you have a drug test. But you can have your client testify. There may be other things that you could do. For instance, if somebody had other tests done that are contrary to that, or the test was equivocal, or there's some problem.
Chain of evidence.
Can you refuse the test? And what happens if you do?
Okay, that's a good question. So that really no. I mean, it comes back to it is. If you ask me as my employer and I am injured to take a test, it's a lawful request. You may legally ask me to do so, and if I refuse, you may legally terminate me.
Do they have to ask? Do they have to ask, or can they just, tell the doctors to do it? I've heard situations like that.
No,
I think they're going to ask, but if it's a refusal, if you just refuse to give blood or whatever. But if it's an emergency situation and you're unconscious and they take your blood, most of the hospitals will go ahead and do an automatic blood test.
They will. So they don't absolutely need permission.
Well,
they'll just do it.
But let's say you do refuse, and as you say, they can terminate you. Does that end your work comp claim?
It can. Yes.
Okay.
Absolutely can. A refusal of taking the test, it actually can.
And I've seen some pretty horrible things around drug tests. I've seen people with some pretty severe injuries where they're insisting on a drug test prior to receipt of treatment. It's absolutely inhumane. It's absolutely inhumane. They have people sitting around bleeding and going, you know what, I want you to have a drug test first. And it's appalling.
This has been a lot of great information. Before we cut off, is there anything else that you feel like we absolutely need to mention, or you feel like we've covered enough?
Well, there are so many topics to touch. There really are.
I would just kind of say that if you have a serious injury, that you probably need a lawyer. It's a general rule. And if you slice the tip of your finger and you've got one stitch, maybe and you're hesitant, you've got a good employer and things are working out, you may not need to call us. But if you've had a serious injury, they have representation. When you end up at the workers' compensation, they will have an attorney, and you probably
right. And it sounds like, from what you're saying, there's really nobody else in the process, including the doctor, who's really objective. It seems like everybody else is sort of on a side a little bit, and you probably need to have somebody on your side that can get you through that process.
Even the judges, when you go to meet the judge on your own, that judge is not representing you.
Right.
He's been told by statute that he does not represent you, and he or she will just say that, and you're on your own.
And it's simple. If you have a question, call us.
Yeah, well, that sounds great. We'll wrap it up there. I'll just remind everybody to subscribe and get a chance to see other great segments like this one. That's really important.
Thanks a lot.
Thank you.